Hey, how's it going? This is David. Here we are with I'm So Offended. And I've spoken to a lot of guys, and like half of which still don't understand that it's the child support scam is separate from custody, has nothing to do with the kids. And I'm just going to basically show you their paperwork that that pretty much says that, and that it's all a contract and all that. Just kind of trying to put some understanding here for you guys to know what it is. They actually involved us in inadvertently or whatever. But anyways, um, I'm not a lawyer. I don't practice law. Um, I'm not liable for the information here, other than this is all for entertainment and educational purposes only. Please, as always, do your own research. As you guys could see in the comments, I don't delete anything. I don't take anyone off or anything. I enjoy when people challenge anything that I've put on here. If I am wrong, I am wrong, and I admit it. And we're all out here for understanding. And anyone I speak to, I tell them the same. I tell them that I give perspective and knowledge based on my experience. Things that I don't know of, I tell them like, hey, this is not my experience. I don't know of this, but we try and we find a resolution and an answer together with anyone I've talked to. And people can verify that anyone I've spoken to, I am very forthcoming and I'm very honest. And, as it is, I don't know everything. I do not, there's other people that know more. And I appreciate their input and their challenge. And I leave these comments up. I'm all for it because we all want the same outcome, right? To be off of this. And as I've said before, my case is in limbo. The Attorney General has withdrawn. It sits with the agency who's just twiddling their thumbs and not doing anything about it. I gave them the law, told them to close it, and they're just not doing anything. I'm not getting garnished. I don't pay anything, and I have like no orders. You can see through the videos that the Attorney General has in fact withdrawn, and they don't even have the case. So, anyways, I don't get letters. I don't get phone calls from the agency. Nothing. It's just sitting out there in limbo, just waiting for something to happen. I don't know. I'm just waiting for them to close it. But anyways, here we go. So a couple of the guys that I spoke to, they're in different states. Different states have different rules and procedures and whatnot. But I'll tackle a couple of the big ones here. And in my state is Arizona, so I'll show you what we've seen there. So what you have here is, and you could look these up yourselves. LDSS 2921. This is the New York State application for certain benefits and services here. All right, I'm gonna see if I can make this bigger. Is it gonna alter the thing there? Maybe just by a little bit because I gotta read it better. All right, so in looking through this, if we're gonna scroll together, all right, so this is basically filling out the application. This is what the mother fills out, right? Okay, let me I have to blow this up. Let me see what it did to here because I can see it, but it's so tiny. I don't know if I actually can see it. Okay, here it is. I don't want you guys to lose anything here. Let me open this up a bit. I think I need to change this. Maybe a little smaller. I think that should be good enough. You're welcome to look this up and follow along as well. If you're in New York, this is New York. I love the small print there. So there's the application for benefits, first and last name. Um, Household information. I actually have a guy that I'm talking to that, the ex talked to him and said that like she didn't expect all of this, so many hearings, so much you know, intricate involvement into their personal family life. Like they want everything. They want medical records. They want job information. They want so much stuff, and it's intrusive. And these females, they don't realize that. These women don't realize how intrusive this all is. And this woman just basically doesn't want to settle with this guy for the sake of here. I'm gonna have to remove this here. There we go. Doesn't want to settle with this guy for the sake of not getting the money. She wants to settle with him because it's so intrusive. It's so intrusive is why she wants to settle with this guy. Um, you know, and so, and I told him, I'm like, all right, you can settle it because it's no different than applying for food stamps. At any point in time, it's an at-will application that can be terminated. Now, as far as child support is concerned, is because of the money that they get back, 66 cents on the dollar in incentives, they're going to try to convince her out of it. If she was just not wanting to do food stamps anymore, nobody is going to tell her nothing and fight for her to stay on food stamps. They're just going to ask, are you sure? And by the penalty of perjury, this is what you agree and sign here. You know, the reason why they try so hard to not let the mom just not be part of it anymore is because of the incentives. They get all that money. Okay, so let's see if I open this up bigger. I just want to make sure that it's still out. Oh, I don't want you guys to not be able to see it. Let me see. I hope that comes out there. No, I still got them. All right, let me see. How's that look? Okay. I think that's good. All right, so seeing it here, SNAP benefits. Let's go down to it. Here it is. The child support enforcement, right? This is the New York application. States right here, if you're applying only for child care assistance, you're not required to pursue child support and do not have to fill out this section, right? Child care. If you are applying for Medicaid, in addition to public assistance or supplemental nutritional assistance program, you may have to help us obtain medical support for yourself and applying children. Answer the following questions to determine if you need to complete this section, including yourself, as appropriate. So this is where it happens here. Are you applying for an individual under the age of 21, out of wedlock, for whom legal parentage has not been established? Yes or no? Are you applying for an individual under the age of 21 who has been an absent parent, non-custodial? Look at that. A non-custodial parent is an absent parent, right? So all these straw man things are true, except you can't bring that stuff out up in court because then they're going to call you sovereign citizen and throw you in jail. But it's still true. A non-custodial parent is considered an absent parent. You basically abandon your child. You do not need to complete this section if you answered no, but if you answered yes, names of all individuals under the age of 21 whom you're applying, and any information you currently have about those individuals, non-custodial parents or alleged parents. Alleged parents. Look, they don't even care if it's even the real parent. So, as a condition of obtaining services, you are required to assign certain rights related to support as described in the notices, assignments, authorizations, and consents section. At the end of this application, you will be provided with the LDS 5145 form referral for child support services to complete return child support enforcement unit. Except in situations of domestic violence or other good cause, as a condition of obtaining assistance, you are required to cooperate with child support enforcement unit to locate any non-custodial parent or alleged parent, establish legal parentage for each individual under the age of 21 born out of wedlock, establish, modify, and or enforce orders of support. You will be provided with LDSS 4279 from Notice of Responsibilities and Rights for Support, which explains your responsibilities and your rights if you do not cooperate with the child support enforcement program. And there they fill out everything, right? Absent child information, teen parent, all of that. They want everything. It's very invasive. Gotta comply. Gotta comply. That's what it says. You have to comply. Look at the top. It says 28 pages. Okay? They have no problem doing that. They don't realize what it is they're doing and the mess that they're involving themselves, their family, the father. They have no idea. All right. Collection of social security numbers, disclosure information, consent for investigation. So PA is public assistance. I agree to any investigation to verify or confirm the information I have given in connection with my request for public assistance. And let's find... educational programs, early intervention, child teen, Medicare, reimbursement, public assistance recoveries. And let's go to, here we go. Applying for or receiving family assistance, safety net assistance, or Title IV foster care operates as assignment of the state and the social services district of any rights to support from any person, any other person that the applicant or recipient may have in their own right or behalf of another family member for whom the applicant or recipient is applying for. Receiving assistance assignment is limited to certain situations. Here we go. Assignment of support rights. I assign. Look at this. You give up your rights to your own kids, to your offspring, the females do, when I assign to the state and social services district any rights I have to support from persons having legal responsibility for my support, and any rights I have to support on my behalf or of any family member for whom I am applying for or receiving assistance. Where applying for or receiving family assistance or safety net assistance, my assignment of support rights is limited to support which accrues during the period that I or any family member receives assistance. However, any support rights that I assign to the state on behalf of myself or any family member prior to continuing to be assigned to the state. So it's right there. Oh, and by the way, look at this at the very end. Complete the following if you want to withdraw your application for one or more programs. Gee, I consent to withdraw my application for public assistance. By the way, if any of you have a reasonable baby mama, which obviously if you're looking on here, that's pretty rare. But once you've been through the mess and you know, and eventually she becomes mature about the whole situation and actually starts putting the kids first in New York, this is how you get off and this is how you close your case. Right there. I consent to withdraw my application for checkmark public assistance. It's right there. And there's your signature. You know? Oh, and then they want you to vote. It's right there. The other form they mentioned that they would give the assignment of rights, which is the LDS 5145. Here it is. Here's referral for child support services. Let me make sure it comes up over here. Okay, it looks like it's pulling up okay. So welcome. That's kind. Definitions: non-custodial parent, parent obligated to pay child support. Custodial parent with primary care, custody of child, and equal shared custody cases is a parent eligible to receive child support. Alleged parent, person who may be a child's genetic parent but who has not yet been legally declared to be a parent. Eligibility. And let's move down. Assignment and cooperation. As an applicant recipient of temporary assistance for the child, Medicaid, yourself and the child, if your child is entitled, that's foster care. There it is. You are required to assign these support rights, and unless you claim good cause or domestic violence for not doing so, cooperate with the child support program to locate non-custodial parents, alleged parents, and intended parents, including biological parents or step parents. Basically, the mother's just an informant, right? Establish, modify, or adjust orders of support, collect and enforce orders. And wow, does this sound like a threat to you? If you are receiving temporary assistance for the child or Medicaid for yourself and the child, you will be sanctioned for failing to cooperate absent a determination of good cause or domestic violence if applicable. And then we have here how it uses the Social Security Act. Services. Let's look at this little gem right here. All right, do you see it? I'm going to try to put it so it's right there in the middle. Your child support case may be closed for reasons including, which means not limited to these reasons, but these reasons including parentage cannot be established. How do they establish parentage? Paternity test, DNA, signing of the birth certificate. Okay. The other party cannot be located after diligent effort or is incarcerated with no chance of parole, permanently disabled with no ability to pay support or institutionalize, or, look at this, the recipient of services fails to cooperate or provide information that is essential to the next step in providing services. So, at any point in time, she can withdraw services, right? So these were just some reasons, and that is not all of the reasons. In New York State, parentage may be established by any of the following ways: voluntary acknowledgement process, which is where you consent, filing a petition with the court, determine paternity, issue order of filiation or filing a petition for the court to determine parentage, issue a judgment of parentage, child support obligation amount, look at this, low income obligation. Now, in this economy, it's not hard to fall into that. Instead of, for some of you, you could consider this doing the long drawn out battle against their state with unlimited resources and these commissioners that don't follow the rule of law. Maybe you can just do a modification if you qualify under low income, and read this: if the non-custodial parent's income is determined to be at or below the federal poverty level for a single person, the presumptive support amount is $25 per month. When income is at or below the self-support reserve, 135% of the federal poverty level, but above the federal poverty level, the presumptive support amount is $50 per month. So I've actually spoken to a couple of guys that were in this situation where they had the option of just a modification where it could be $25, $50. And you got to think long term here because of the things that they can do to you, right? Your passport, driver's license, your taxes, levies, and all that. I spoke to a guy who had his bank account levied, right? If you fall under this low income obligation, which many of us do, it is worth, as they say, settle your affairs with your adversary quickly. The price of peace of mind can be $25 a month. The price of peace of mind can be $50 a month. Who cares? Who cares? If you get an order for 25 or for 50, who cares if you pay that? Who cares? That is worth the peace of mind over fighting this out, filing countless lawsuits that they're just going to throw out, going through contempt proceedings that half of you don't know how to defeat, and just losing your job, getting garnished from your job, getting your license revoked, and all that. So modification can be a remedy for some of you that you should consider. You know, I understand pride and dignity, but sometimes not being in jail, not having your license revoked, not having your taxes taken is your pride and dignity in order to only pay $25 or $50. Something to consider. Rights of information, distribution of payments, and so on and so forth. And so this is what they would be giving them in order to, you know, to get it started. One is for benefits, and this one is specifically for child support, right? And this is how you fill all that out. This is 13 pages. Again, look at this, very invasive, just giving all your information to the government. And here we go. They want to make sure that they know that you agree to all this. And some people just sign these things. Actually, with the women, they just sign these things and they don't care what they're signing up for. I hereby subscribe and affirm under the penalty of perjury that the information I have provided in the referral and any accompanying documents has been examined by me. The best of my knowledge and belief is true and correct. I agree to the child support program immediately of any new or changed information I've provided in this form. It says you have to basically repay overpayments. I understand child support may send correspondence electronically. And look at they get a $35 fee right there if I'm found ineligible for temporary assistance benefits. It says, I understand I will be charged a $35 annual service fee if they collect at least $550 during each fiscal year. Let's keep going down because there's more stuff here. And provide copies of all information. So there you go. This is what they do. And then this other one, we saw that you can, that's how you get out of it. The mother wants to withdraw my application, right? All right, now this is New York. This is what they put you through, and this is the consents, and we already know that they're assigning the rights to the government. This one here is Texas. What this here is, because in Texas the agency is housed in the Attorney General. This is if you're already receiving uh, services. Check this out. By merely requesting a review. By the way, this is the form number. What is it called? It's very small there. If you can see it, 350L. 3L015C. All right. So this is how you can close out your case in Texas if you have a reasonable mother, right? So I request the Child Support Division of the Office of the Attorney General conduct a review of my child support order. I understand the attorneys of the Office of the Attorney General represent the state of Texas. They will provide me with child support services, but do not represent me or any other individual. They don't represent the families. They don't represent the kids. A review of a child support order will determine if the order complies with the Texas child support guidelines and may result in an increase or decrease in child support or change in medical coverage. Reasons you're requesting review, right? There you go. So you would fill this out. Child support review. Now, if both parties agree, you don't have to fill out the whole entire thing. You just need to put in the information of each individual and the child. Financial, you can cross this out. Just put an X over the whole thing. As long as you put down the children. Because these are just ready forms for you because they don't want to close the case. They don't. So they have it in such a way that you continue, right? And you can put down your reasoning. Any information we should consider that should not be covered in here. You could say, I do not consent to receiving services. I do not want services anymore. And your reasoning here can be family code. This is for Texas. Title V, parent-child relationship, and the suit affecting the parent-child relationship. I gotta make this smaller so you guys can see it here. There we go. A little bit more so you guys can. Let me see if you get the whole form. Okay. The whole form comes out. So now let's go down. This is the child support for Texas, right? Section 154.006, termination of duty of support. A, parentheses, unless otherwise agreed in writing. What that means is the contract clause of the United States Constitution, Article 1, Section 10. Unless otherwise agreed in writing, which means when two individuals have an agreement, it supersedes government contracts, including child support. After that, or expressly provided in the order, or as provided by these subsections. So it says marriage of a child, removal of child disabilities, death of a child, finding by court of 18, or failure to comply with enrollment or attendance required, issuance under all these things. But the first thing, unless otherwise agreed to in writing, and it doesn't say and expressly provided in the order, it says or, meaning that two individuals, the mother and father, can at any time agree to terminate support, and their agreement and their withdrawal of consent to the agency supersedes everything else in A, writly expressed in the order, or in the marriage of a child, or removal of disability, all of that. The first part is an agreement. Everything is contracts. Everything is contracts. And in your child support review, due to agreement by parties according to Family Code Title 5, Section 154.006, termination of duty of support, parentheses A, unless otherwise agreed in writing. Parties do not consent to services and wish to withdraw from services. Parties have made a private agreement. There's your explanation. There's your signature. Signed. And there's your withdrawal of services. That's Texas. Now let's look at, we've looked at New York. We've looked at Texas. This is Arizona. How can, this here is CSE-1051A, how to apply for services, right? Check this out. So this is in page 4. And I'll go to the beginning here so you can see what this is. And let me make this smaller to make sure that you guys can see it. And let me remove that. Okay, I think you can see it all. All right, let's move down. Okay, so this is where we were. And let's go down to the part there. Okay. If at any time the consequences of collecting child support outweigh the benefits, it may be safer to close your case. If you are receiving public assistance and it is not safe to open a case or receive child support services, DCSS can provide a good cause waiver that stops the child support services. Now, this all has to do with domestic violence, but nothing more than a good cause waiver can stop the child support service process. Let's see, what was the other part I wanted to show you guys here? Oh, it was this actually. This here. All right. This is the application. Okay. All right. Just want to make sure that it fits here. All right. This is 18 pages for Arizona. Application fee. Rights and responsibilities. Cooperation includes, again, they want to, you have to cooperate. They can sanction you, and basically it's under threat. You know, you go after the father, and you have to give them all the information, strict requirements of state and federal law. Look at this, a customer. Case closure. Under circumstances permitted by federal law, your case with DSS may be closed if the facts of the case establish an inability to take action to collect child support. By the way, that's that can be a failure to basically prove ability to pay, right? If they have failed to cooperate, your cooperate is essential for the next step in providing services, and you do not receive public assistance benefits. You provide a written request that the case be closed. There is no child or medical support that owe pursuant to a court order and assignment to the state, and neither you nor the children receive public assistance. DCSS has been unable to contact you within a 60-day calendar period, despite attempts by both telephone and at least one letter by first-class mail. and you accepted direct child support payments from the non-custodial parent after your 40 case was opened. This prevents DCSS from maintaining accurate debt balances. Gee, that sounds like you accepted direct child support payments from the non-custodial parent. That sounds like a private agreement, doesn't it? And you can provide a written request that the case be closed. Legal representation. The Arizona Assistant Attorney General and Deputy County Attorneys do not represent you or your children in child support proceedings. They represent the state of Arizona. You have the right to have a private attorney at your own expense in addition to services provided by DCSS. So, this is just to show you that pretty much within the states they're consistent as far as private agreement supersedes them. Okay? You can withdraw from services at any time. Okay? And child support services has nothing to do with the family or the kids. If you're going to call me, we're talking about your case and how to avoid jail, how to avoid pain. We're not talking about custody. Okay? I have talked to some guys about custody, and I just basically looked up their rules and procedures. I talked to a guy that was going through a temporary orders. I looked up the rules and procedures. I'm like, this is why they're doing what they're doing, and this is your affirmative defenses. You just pump in the code as to why they're doing what they're doing, and you'll find it right there. But if we're talking about your child support case, if you start telling me about your kids, like as I've told some of the guys, like I'm gonna stop you right there. It has nothing to do with it. If she doesn't let you see your kids, I'm sorry. I know what that's like. I've gone through that twice. That has nothing to do with child support. Absolutely nothing to do with it. And we're hearing it right here from the mouth of the beast. All right? So, comments, and everything, I respond to as much as I can whenever I can. And you can, if anybody has talked to me on the phone, you know that I'm a man of honor. I don't give away people's paperwork that I paid for and things like that. But I have put together, some things that I provided, at least kind of direct you in a path to at least avoid jail. Ultimately, that's where your constitutional rights are infringed upon, and you got to stand your ground, as you've seen in my court hearing videos. So, and it does take my time. I do appreciate any and all donations for, providing this information and this and that. It is very cheap. It is not a lot. You can see that, other people charge $150 to talk to them, thousands of dollars to represent them. But if they can provide you the remedy that you want, then I'm not against that. I'm all for it. I'm all for it. It is your choice to, do as much due diligence as possible. If you pay someone $2,000 to help you out, it's still cheaper than paying 10 grand. Okay? I've never charged anything like that, and but I haven't gotten anyone off child support. I'm being honest here, but I have helped, I think, like 3 guys now beat contempt. Okay, so you choose to do what you want with that information, and as always, I'm honest. I'm a man of honor. I appreciate everybody's comments and everything, and this video is for education and entertainment purposes only. And I'm not a lawyer, and I don't practice law. I've just been through this, and it is damaging to all of us. All right. Till then, please like, share, and subscribe, and thanks.